My name is Chuma Chinye, and I am your family lawyer. My name is Chuma Chinye, and I am your family lawyer. It is my honor and privilege to share this space and time with you on our weekly podcast, Your Family Lawyer. Before we dive in, please don't forget, hit that subscribe button so you never miss an episode. If you care about protecting your family's future and avoiding legal pitfalls, you're in the right place. Call us today or send us a message and let's help you take the right legal steps. In today's episode, we'll delve into a critical area of Nigerian family law. We'll talk about inheritance disputes. We'll talk about the causes, the types, and the remedies. We'll explore major contributing factors to these disputes. We'll support them with stories told from decided Nigerian cases. Experience, they say, is the best teacher, but trust me, it is better if you are not a member of that class, where and when the lessons were first delivered. Inheritance disputes are common in Nigeria, often arising from various causes and taking different forms. Today, we'll show you some of these causes and the types of disputes. In Nigeria, inheritance disputes are not just legal squabbles. They are family earthquakes. When it comes to inheritance, daggers are drawn. Siblings who have been friends for decades become sworn enemies. Pastors, babalawos, wives, husbands, and even some crooked lawyers become willing tools in the fight to finish. But why all this drama? It's because Nigeria operates under three legal systems. We have statutory, what we call English legal system, which we inherited. Then there is the customary law, which applies in your tribe or your ethnic group. Then, of course, there's the Islamic Sharia law, which is applicable mostly in northern Nigeria. Often these systems clash like rams in a village square, leading to chaotic, lengthy, and bitter disputes. Of course, there's the role of greed, avarice, wickedness. But let's break down the top causes of inheritance disputes in Nigeria. The very well documented causes include when somebody dies without making a will. This is the kingpin of all problems. According to a 2023 survey by the Nigerian Bar Association, over 78% of Nigerians die without making a will. And this usually is because in our culture, talking about making a will is like inviting death. The absence of a clear will, a clear and valid will, can lead to disputes among family members. And of course, cultural and traditional practices contribute to this. Our different practices lead to conflict because there are expectations that are not met, and disputes that arise destroy families. Family members usually have different expectations, and these dynamics lead to disputes. These include cases like sibling rivalry or conflicts between spouses, and these contribute to inheritance wahala. Now, disagreements over the value of properties too can lead to problems. And these disputes between beneficiaries are fueled by greed and inability to accommodate other family members. The tendency to grab it all for yourself often leads to tension, to conflict, to hatred, and to long-drawn battles. And there's also the constant issue of perceived or real favoritism of preference of one child over the other by the deceased benefactor. Let us talk about the types of disputes. Disputes may arise over the distribution of property, including land, buildings, and other assets. Disputes over the validity of a will may also arise. And when this happens, it's usually cases of allegations of forgery, undue influence, or just not being satisfied with what one got. Disputes may arise over cultural and traditional practices, including the application of customary law. Africa Magic Epic has a plethora of movies on these types of disputes. You know them, often involving Patience Ozoko and a few other great actors. Now, sometimes a man dies and then his family assets are taken away from his young widow and children, and they are thrown into the streets, into poverty and into misery. One of the best ways to resolve inheritance disputes is by mediation. And this will involve negotiations, a third party, and to persuade the warring parties to see things from a different perspective. When this fails, of course, there is litigation. And where disputes cannot be resolved through mediation or arbitration, of course, you go to court. And when you go to court, it drags almost always forever. But it's important to seek professional advice in any event. Talk to your lawyer, talk to your accountant and other experts that can help you to navigate inheritance disputes. When you talk to these persons, they may help you to understand the causes, the root causes of these disputes, because understanding them can help you resolve what the issues are. Indeed, they're often complex, but we don't know it. Having laid down what I think is appropriate foundation, let us now dig deep into some of the big issues in family disputes. Come closer, just a little closer, because one of them certainly affects you. Yes, you. And so don't forget, click the subscribe button if it is you. And if you find this valuable, share it with some other person. Let's talk about how divorce and second marriages affect inheritance disputes in Nigeria. When a man or a woman gets divorced and marries a second time, this could be a catalyst for inheritance disputes in Nigeria, particularly in cases where there are complex family dynamics and multiple relationships involved. Let me show you some of the ways that this happens. In divorce and second marriages, conflicting loyalties and tensions between family members, particularly where there are children from previous marriages, can be a major cause of inheritance disputes. In some Nigerian cultures, customary law governs inheritance, which may not provide clear guidance for inheritance in cases of divorce and second marriages. Statutory law may make provisions, usually have provisions and guidelines for inheritance, but this application can be very, very confusing when divorce comes into play and second marriage, a man or a woman marries a second time. Because sometimes the questions about the validity of the second marriage could be the problem. At other times, aggrieved children from the first marriage or the jilted wife can fuel and aggravate the wahala. You know what I'm talking about. Disputes may arise over the distribution of the property, including land, buildings, and other assets. Allegations of favoritism towards one spouse or one set of children from a spouse may lead to disputes. Understanding the role of divorce and second marriages in inheritance disputes can help individuals and families navigate these complex issues. Sometimes a man or a woman has married previously, and maybe a spouse is dead and you have a set of children from that family. Because of the love you had for that wife or husband, you favor those particular set of children over the children that came from a new marriage. This can be a big cause of problem when it comes to inheritance, because your mind is reflected in how you wrote your will or how you shared your assets. I think we've spoken a lot about how this is in law, but let me tell you one or two stories that will help you to digest what we're talking about in practical terms. The case involving a certain Mr. Ilorin that was decided in 1983 by the Supreme Court of Nigeria. The man had children from two different marriages. He died intestate. His estate became the subject of dispute between the children of both marriages. The Supreme Court affirmed that the legitimate children from both marriages are entitled to inherit. But the lack of a will led to extended litigation. And this litigation, during this period, the properties wasted and the people suffered. Under statutory law, divorce or second marriages should prompt the drafting of a new will to prevent disputes. Failure to do so can leave surviving spouses or children from prior marriages unprotected. Therefore, my advice would be, if you get divorced or if you are widowed, quickly take a look at your will if you had made one previously. If you haven't, make a new one. But if you had made one, make adjustments to accommodate your new status. Because if you don't, you're going to leave a lot of challenges for the children or the surviving spouse, or both of them. Blended families, which is what we've been talking about, where somebody is already married and had a child or two and then marries again, can be a nightmare if not well managed. Let me try to explain this from what happened in the case of Okonkwo and Okabue, decided sometime in 1994. A man informally adopted a child. After his death, the biological children contested the adopted child's claim to be part of the estate. The court looked at this, and the child found favor with them. And the court said, look, this child is entitled to also inherit from the estate. But the court emphasized the need for formal adoption or inclusion in a will to be sure that such children do not suffer when their benefactor dies. I will now talk to you about the role of polygamy. For those of us who like to have multiple wives, it is recognized under our customary law. It is recognized under Islamic law. It's a practice where a man can have multiple wives, but this can be a nightmare when it comes to inheritance. Here are some of the ways that polygamy can contribute to inheritance problems. Polygamous families often have complex dynamics with multiple wives and multiple children. This can lead to disputes over inheritance. Each wife and their children may have different interests and expectations regarding inheritance. Some may think that, oh, I'm the first wife, so I should be favored. The other may think, oh, I'm the newest, I'm the new jewel, and I should be favored. But this could be problematic for a man when it comes to how you resolve your estate before you go home. Islamic law is helpful because it has specific provisions on how this can be handled. But our customary law often doesn't help much, except that of the Yoruba custom, which often allocates properties according to the number of wives and children. The absence of clear documentation, usually in customary inheritance, can be a major problem, which is where Islamic law has an advantage. But you can cure this by making a will. When you do not make a will and you're under customary law, there's chances you're going to have problems. In the case of Mwariako, which was decided in 2003, Chief T.E.A. Salobi died intestate, leaving behind a widow he married under the marriage ordinance. He had 2 children from that marriage and 2 acknowledged children born out of wedlock. The eldest son claimed the estate under Urobo customary law. The Supreme Court held that the estate should be distributed according to the administration of estates law and not customary law, judging the nature of the marriage that the man conducted. And so they granted the widow 1/3 and the children, including those born out of wedlock, 2/3 of the estate. The point we're trying to make here is that the court favors statutory provisions over customary claims in polygamous contexts, ensuring equitable distribution among all legitimate heirs. But you need to be careful about this because if you were married under traditional law, the courts will be sure that it's the custom that applies, except that custom offends our laws. I had talked to us a little bit about sibling rivalry and spousal influence in inheritance disputes. There are many ways this can contribute to problems in many homes. Sibling rivalry can be a long-standing issue with conflicts and tensions between siblings that have been simmering beneath the surface long before their father or mother dies. And this can come to the surface when it comes to sharing of assets. But the parents can deal with this if they made a will. And you can then ensure that each child gets what is fair, gets what is due. In such situations, siblings may easily perceive favoritism towards one sibling over the others, leading to resentment, leading to disputes. Among biological children, rivalry often arises over the control of an estate, and this is quite common where one sibling has been more involved in caregiving to the parents or in running a family business. Some time ago, the family of Fap Ohunda was involved in this kind of matter. The eldest son, who managed the father's property, was accused by the younger siblings of attempting to appropriate assets to himself to their exclusion. The court held that the concept of primogeniture does not apply under statutory law, and that all the children, regardless of gender, are entitled to equal shares. The point to note here is that eldest sons do not have special status under statutory succession unless provided in a valid will or applicable custom. Now, what is primogeniture? We're going to talk about this in a subsequent episode, but primogeniture is a traditional practice that makes the first son the head of the family and often allowing him to inherit everything. We'll devote part of an episode to explaining this subsequently. Let me expatiate just a little about the influence of spouses in family disputes regarding inheritance. Sometimes a new spouse can be the love of the life of the new husband, but it must be managed carefully because there are existing children in most cases where a new spouse comes to play. And this could be problematic, big time problem. And this is one of the underlying causes of inheritance disputes. If you marry a new wife, be sure to make your will in such a manner that you accommodate every other person. Trending recently is that the case of Emmanuel Iwanyanwu, who had children and married after his wife passed on at the age of 70. He's dead now, leaving behind a 38-year-old widow. A lot of people are commenting on why he made his will the way he did it. All he just simply did was transmute custom into his will, which is permissible. Culturally, extended families are part of the lives of nuclear families in Nigeria. And even though we are now quite inclined to getting them away from playing roles in families, when it comes to inheritance, extended families play significant roles. They are the ones you see often on television who go to remove a widow and her children from her late husband's home and throw her onto the streets. But they're also the ones who can be very helpful when tragedy strikes. They're the ones who take over the training of children. It depends on the family, it depends on how you manage it. If you're married to your wife, be sure not to estrange your family members in a manner that will make them enemies of your wife when you pass on. Having said this, extended family members could be greedy. They may have vested interests in their hearts as to what their sibling ought to do with his or her property. And if he didn't do that when he was alive, when he's dead, they will move in like hawks, and they may cause a lot of problems. But as I mentioned, they could be big-time mediators to help resolve problems. And they often help to find resolution that works for extended family issues. You need them, but you just have to be sure that you have the right ones. Extended family members may influence decision-making regarding inheritance, particularly if they have a close relationship with the deceased or his or her family. The challenge is, though, that family members, extended family members, that is, can be difficult to manage. You may have, if you have 70% in your favor, then you're good to go, because you don't expect that every one of them will behave in the way that is fair, equitable, and just. But this is often why you need to make a will, so that you don't give excessive powers to your extended family members regarding your assets. The family of Nzeku had experienced something that of the kind we are talking about when a widow and her children were ejected from their family, from her matrimonial home by the husband's extended family. She was thrown out. The matter went to the court, got up to the Supreme Court, and of course the Supreme Court held that the widow had the right to occupy the property and that the extended family members could not override that position of the law without any lawful authority. The point to note here is that increasingly the courts protect the rights of the nuclear family over traditional extended families. But you can help the courts by making clear provisions whilst you are alive, such as using a will or a trust. When you do this, you can make sure that the children are either equally provided for or in a manner that it is fair and just, and that it is unlikely that people will proceed to court. There is also the issue of next of kin, which we had devoted a whole episode to previously. We'll bust that myth in episode 20. People think that if you make somebody next of kin, you have handed over your property to the person when you die. No. My wife may not like to hear this. She's my next of kin in every document, but that doesn't mean that she's the one who inherits everything when I'm gone. It is not the law. What the law is that the next of kin does not confer inheritance rights. Only statutory beneficiaries under the administration of estate law or a valid will or that custom can inherit your estate. The next of kin is just an administrative term. It does not equate to legal inheritance rights. Please note this and have wisdom. Then how can we prevent these conflicts that we're talking about? The first thing you need to do is draft a will that is valid. Engage the services of a good family lawyer to help you do this. And when you've done so, update the wills regularly. If you have a good lawyer, he will draw your attention to this. If, for instance, you had a child through surrogacy, ensure that you do proper adoption and formalize all the processes. So that way you can secure the inheritance rights of the child involved. Now, my final word for today. Inheritance disputes in Nigeria stem from a blend of cultural practices, legal pluralism, and inadequate estate planning. The judiciary has consistently upheld statutory laws and constitutional provisions to ensure equitable distribution, regardless of gender or birth status. Proactive estate planning and legal awareness are vital in mitigating these disputes. Whilst you're still alive, whilst you still can, take immediate steps and take them now to ensure smooth, seamless transitions of your estate. It seems to me selfish and difficult to rest in peace whilst your family boils upon your demise. It's not tomorrow that you should call a family lawyer to sort things out. Make that call now or visit our website for guidelines on what to do. Now, let me thank you for joining us on today's episode of Your Family Lawyer. If you found this episode insightful, please subscribe, like, and share. Remember, proactive planning today prevents disputes tomorrow. And remember, when it comes to your family's legal peace of mind, don't wait for trouble. Call us today or send us a message for legal consultation. Until next week, when we visit you with another episode of Your Family Lawyer, stay informed, be empowered, and by every lawful means, be good to your family. My name is Chuma Chinye, and I am your family lawyer.